One word decides whether your family gets your house in 6 months or in 3 years. That word is probate. Almost nobody explains what it actually is until it's too late to do anything about it. So here's what it actually is, what it actually costs, and what actually gets you out of it. Probate is a court-supervised process. It happens after someone dies, whether they left a will or not. The court verifies the will if there is one, appoints someone to manage the estate, identifies everything the person owned, pays off debts and taxes, and then distributes what's left to the right people. Bank accounts, real estate, investments, almost anything owned in your name alone, without a designated beneficiary, goes through this process. A will does not skip it. A will only tells the court what you wanted. The court still supervises every step of making that happen. Let's talk about what it costs, because the number surprises most people. Probate typically runs between 3 and 7% of the estate's total value. On a $500,000 estate, that's $15,000 to $35,000, gone before anyone inherits a cent. On a $1 million estate, costs can run as high as $50,000. Where does that money go? Attorney fees make up the largest piece. Some attorneys charge by the hour, anywhere from $250 to $600. Others charge a percentage of the estate. Executor fees come next, usually capped by state law at somewhere around 3 to 5% of the estate's value. Then court filing fees, appraisal costs for property and valuables, and smaller administrative expenses, postage, notices to creditors, and more. The exact number depends heavily on where you live. California uses a statutory fee schedule based on the estate's gross value, which means costs are predictable but can climb fast for larger estates. A $500,000 estate in California can generate around $13,000 in statutory fees alone. Texas works differently. A simple, uncontested probate there might total $3,000 to $7,000. Attorney fees closer to $750 to $1,500, plus a few hundred in court costs. Now the timeline, because cost isn't the only thing families underestimate. A simple, uncontested estate typically takes 6 to 9 months. An average estate runs 9 to 18 months. A complex estate, one with disputes among heirs, a business, significant tax questions, or property that's hard to value, can take 2 to 3 years, sometimes longer. And here's the part that compounds the cost problem. The longer probate drags on, the more it costs, because attorney hours and administrative expenses keep accumulating the entire time. There's a third cost that doesn't show up on any invoice: privacy. Probate is a public court proceeding. The filings are public record. Anyone, a nosy neighbor, a distant relative, a stranger who reads court dockets for a hobby, can look up what your estate contained and who received what. For families who'd rather keep financial matters private, that's not a small thing. So that's the problem. Here's what actually gets you out of it, and none of these are theoretical. Each one is used every day by attorneys to keep specific types of property out of probate court entirely. The first is a living trust. You transfer ownership of your assets, your house, your accounts, your investments into a trust while you're alive. You still control everything inside it. Nothing changes day to day. But legally, the trust owns the assets, not you personally. When you die, the trust doesn't die with you. It simply passes control to whoever you named as the successor trustee, with no court involved at all. The catch, and it's a real one, is that a trust only protects what's actually inside it. Creating the trust document isn't enough. Every asset has to be formally retitled into the trust's name. A house needs a new deed. A bank account needs to be retitled or have the trust added as owner. Skip that step, and the trust exists on paper while the actual property still goes through probate like nothing happened. The second tool is a transfer on death deed, sometimes called a beneficiary deed, depending on the state. This one is narrower and simpler than a trust. You record a deed that names exactly who inherits a specific piece of real estate the moment you die. You keep full ownership and control while you're alive. No court, no waiting, no probate for that one property. The limitation is right there in the description. It only covers what's named on that deed. Everything else you own still needs its own plan. The third tool is joint ownership with the right survivorship structure. If you co-own property as joint tenants with right of survivorship, your share passes automatically to the surviving owner the instant you die. No probate required. This only works with that specific ownership type. A related structure, tenants in common, does not include automatic survivorship. Under that arrangement, your share still goes through probate and passes according to your will or state law, not automatically to your co-owner. Two ownership types that look nearly identical on a deed can produce completely different outcomes. The fourth tool is a beneficiary designation, and it's the one people forget about most often because it's not attached to a will at all. Retirement accounts, life insurance policies, and many bank and investment accounts let you name a beneficiary directly on the account. When you die, that asset transfers straight to the named person automatically outside of probate, regardless of what your will says. This is also why keeping these forms updated matters as much as updating a will. An outdated beneficiary form can send an account to an ex-spouse or a person who's no longer part of your life, no matter what your current will states. None of these four tools require choosing just one. Most complete estate plans combine several: a trust for the house and major accounts, a transfer on death deed for a specific property, updated beneficiary designations on retirement accounts and insurance. Together, they can move an estate through the transfer process in weeks, privately, instead of months or years in open court. Probate exists for a reason. It settles disputes, verifies debts, and protects creditors and heirs when there's genuine uncertainty. But for a straightforward estate with a clear plan already in place, it's often an expensive, slow, and public process that a bit of paperwork done years in advance could have avoided entirely.